So next week I have two green card interviews coming up for clients. One of them doesn't live in my area, so that means that they're going to be interviewed in another state. And there was this issue that came up about whether or not my client should hire a local attorney to represent them at the interview. And I recommended that my client consider this as an option strongly. You can do that. You can hire another attorney to represent you at your interview if your current attorney is not able to go. Um, so just know that in case clients weren't aware, I actually get hired to do this more and more now because of the importance of immigration interviews, the higher frequency of interviews that are scheduled by immigration nowadays for green card applications. So I've been asked both by other lawyers, who are not located in like my area to go with their clients to their interviews. I've also been contacted by clients who, find me online. And sometimes they have an attorney, sometimes they don't. They filed the application themselves, but they're hearing that these interviews are, going a lot stricter these days. So that's a notable difference from how things were done in the past. So anyways, I have a client who has an interview this Monday. It's for a green card based on marriage. I told him he should hire a local attorney. He didn't get around to doing that. So what the approach that I'm taking now is that I prepared my client with a letter signed by me, and I instructed him to hand it over to the immigration officer when he checks in for his interview. And what this letter says is that I'm asking the immigration officer to allow me to represent my client by telephonic appearance. So this is something that in the past, I don't think immigration was really allowing to happen, but because of COVID, because of the social distancing, when USCIS got back to scheduling interviews, they started telling clients that there is this option that your lawyer can represent you remotely by telephone if they cannot be there physically with you. And this is kind of carried on even after the pandemic. I don't know if all USCIS offices offer this, but I know that in New York City and Newark for sure, it's a routine request that, immigration honors for the most part. Um, so the question is, we don't really know if all USCIS field offices will honor this request. So I had to do some research, talking to other colleagues that practice in this particular city where my client's interview is. And I was able to confirm with a few fellow attorneys that yes, this office will honor a request for telephonic representation, but you need to request this in writing beforehand. So that's what we're doing. And hopefully this office will accommodate my request. Um, But it does have me a little worried because my client's green card is not a straightforward application. There are some issues, and you know, there's a certain level of uncertainty. I've already thoroughly prepped my client beforehand, but um, immigration can be unpredictable. You don't know what kind of officer is going to be interviewing you. Um, How knowledgeable are they with the immigration law? How experienced are they? Um, what is their personal view on immigration? Officers are human beings. Some of them can be fair and apply the law correctly, and sometimes some officers may let their personal biases affect their outlook of the case and their decision-making process. So these are all questions that kind of keep me up at night sometimes. They're kind of things that are beyond your control, right? You can prepare your client as best as you can, but you can't predict what kind of officer will be reviewing the case and making the ultimate decision. So that's one interview happening next week, and then I have another interview later on that week as well that I just prep my clients for. And it's also an adjustment based on marriage to a US citizen. Um, Interestingly, both of my clients who have these interviews are currently on DACA. So that's the whole other thing is, yes, they have DACA now, but it's not really a status, right? It's not, it's kind of like an in-between situation where immigration has granted someone deferred action, which means that immigration knows that someone doesn't have lawful immigration status, but they're allowing DACA recipients to continue living and working in the US. Um, but DACA is kind of up in the air. It's in litigation right now. There's a bunch of states, most everyone knows, who have sued to remove DACA. And right now, we don't really know. DACA does still exist in some form for, individuals who applied when it was first announced. And then there is this um, whole other class of dreamers who try to apply for DACA, but because of this ongoing litigation, their DACA applications are just kind of in limbo, right? So USCIS accepted these filings, these later filed DACA applications, but they're just sitting on them. They're not adjudicating them. They're just kind of in this holding pattern. So that's another complicating factor with these two interviews that are coming up is what if the adjustment applications aren't approved? Then my clients still have DACA to fall back on, but you know, we don't know what the future of DACA is, and it's not looking great. So just some of the things that have me kind of like on my toes a lot lately. Hopefully both my clients will have good results, but as an immigration lawyer, we can't ever guarantee what the outcome will be. It could be the strongest case, but USCIS ultimately can sometimes make the right decision or the wrong decision. So to be continued. Hopefully, I'll have good news next week. Um, and some of the other issues that I dealt with in my consultations this week. One issue that is happening a lot is USCIS placing clients into deportation proceedings. And specifically, these are clients who, let's say, were on a work visa, such as H-1B, but then they were let go by their employer. And usually, when employer ends the employee relationship, um, they oftentimes send a written notice to immigration, asking immigration to um, revoke the approved H-1B petition. So that puts a lot of the H-1B workers who have been laid off, if they've put them, that puts them in a very precarious position because now immigration is being told, oh, this H-1B employee is not working in the US anymore. And yes, there always was this 60-day grace period where the laid off H-1B worker has roughly 60 days um, to take action, to do something, whether that's find another employer who's willing to transfer their H-1B or to change their status from H-1B into something else, like maybe the employee decides to go back to school and request an F-1 visa. But now this whole 60-day grace period is not being honored by USCIS. Instead, what USCIS has been doing is sending NTAs to these laid off H-1B workers. And the NTA is a notice to appear, which is a charging document placing someone into deportation proceedings. So I had a consultation earlier this week for someone in this very same position. He was on H-1B for many, many years, then was laid off by the employer. And the employer filed a written notification to USCIS requesting USCIS to withdraw the H-1B approved petition. So when USCIS received this employer notification, they sent an NTA to this client, scheduling him to appear before an immigration judge, and the court date is very soon. So obviously, the client was very worried, not sure what to do. Last thing he was expecting to happen. Um, so in his case, he actually did have pending adjustment applications, which was a relief. Um, so I advised the client, yes, it is very scary that you have been told that you have to appear in immigration court in the next few short weeks. So I kind of mapped out like a legal strategy for him. My advice to him was that he should file through his attorney, whoever he ends up hiring, a motion to terminate proceedings with the immigration judge. Um, and what is a motion to terminate? It's a request that the immigration judge end the deportation proceedings, and you have to have a good reason. Usually, the reason is that the client has some kind of relief from deportation that's immediately available to him. So, in this case, it turns out that he is already married to a US citizen. He's eligible to adjust. So, he actually filed an adjustment application based on marriage recently. Um, So the chances of the judge granting this motion, I think, are fairly strong. The other equation that you have to kind of figure out is who's my immigration judge, right? Because just like USCIS officers, judges just run the gamut, right? Are they a fair judge? Are they a harsh judge? How experienced are they? Um, so that's the other thing you want to do. If you ever find yourself in the situation, you want to do your homework and find out what kind of judge do you have? So I looked up this client's judge, and you can find out who your judge is if you have an alien number. You can go on immigration court's website and enter your alien number, and it should pull up if you have a court proceeding, if you have been scheduled for a court hearing, it should tell you that information. And in this case, I was able to find out who his judge was. I did some research on this judge, got some good feedback from other immigration colleagues. So I did a little homework for him, and I kind of was able to share some good news that this judge has a good reputation, is very fair, is experienced. So in uh, my feeling is that this judge would probably um, consider the motion to terminate and give it a fair, a fair shot, basically. So hopefully, that's what's going to happen. I'm hoping that the deportation process is terminated and that he can proceed to finalizing the adjustment based on the marriage with USCIS. The other way this case could play out is that for whatever reason, if the judge decides not to terminate, or maybe the Homeland Security attorney might be opposed to termination. They may say, no, we don't, we're not okay with immigration court terminating proceedings. The other alternative way that this case could play out is that the judge could take jurisdiction. Actually, the judge would have jurisdiction over this adjustment because now the client has been placed into proceedings, and the judge could issue a decision on the adjustment. That wouldn't be terrible either, right? But you would want your immigration lawyer to kind of do a similar analysis. Is it better to have an adjustment be handled by USCIS or by immigration court? In some cases, it's better to have a case stay in court. Those would be, for example, if you have a really good judge who understands the law. A lot of immigration judges um, have a lot of experience with immigration. And they, generally speaking, would be more knowledgeable of immigration law than a lot of USCIS officers. This is kind of a very kind of general statement. I'm not saying this as a blanket, but those are some of the considerations that I kind of go through when I'm trying to think through what's the best legal strategy for my client. Um, Another good reason to keep a case in court is similarly, right? How will USCIS adjudicate the case? If it's a really tricky adjustment, and there's discretionary issues, like red flags or negative facts about the case, then maybe USCIS would not be likely to approve it, right? So then you would want to weigh, okay, what are the chances of my adjustment being approved? Are they greater before this judge or before USCIS, right? Um, in this client's situation, I think his adjustment was relatively straightforward. There weren't any red flags. So whether or not it's the adjustment is processed by USCIS or the immigration judge, um, both would likely end up approving it. But the other thing to think about is time frame, right? How quickly will the immigration court act versus USCIS? And that all depends on the judge as well. A lot of immigration judges are swamped, right? They're handling record numbers of deportation cases. Their caseloads are insanely heavy. So we don't know with this judge if he were to take over the adjudicating of the adjustment, when would that happen, right? When is the next available court date? Is it a year from now? Is it 3 years from now? So that's something else that I explained to the client. You probably want to talk to your attorney about this. At your first court hearing, these are probably issues that the immigration judge should be discussing with both the client's attorney and also Homeland Security. So if the judge, let's say, happens to have like a pretty short window where they can schedule the adjustment hearing, then it might be worth it to keep the case in court, right? It also depends on which USCIS office is going to issue the decision on the adjustment. Is it the local field office? And then you want to know more about your local field office. Are they generally reasonable when it comes to issuing decisions on cases, especially adjustments, or are they one of the more difficult field offices? So there's a lot that goes into like kind of anticipating what's going to happen and what would be the better path to choose. So I know it's a lot, a lot of issues to cover in a single consultation. Another consultation I had was for a client's parents who um, are green card holders, and they are citizens of Venezuela. So I'm sensing that there's a lot of fear from um, clients from certain countries that are kind of being targeted right now, Venezuela being one of them. And the reason why the client booked the consultation for her parents is their green cards are about to expire in about a year. And they've heard so many bad things in the news that they were so worried about whether or not something bad would happen to them if they filed their green card renewal applications. So that's why they wanted to speak to an attorney. They thought that maybe just by simply applying to renew their green cards, that this would trigger immigration to come and arrest and detain them. So that's the level of fear that's, kind of out there. Um, no red flags, no issues about having previous arrest records, no unusual immigration history, nothing like that. It's simply stemming from the fact that they're citizens of Venezuela. So I told the client and her parents that, you know, when you are applying to renew your green card, um, that process does not require an interview with immigration. And that was something that they thought was part of the process. They thought that they would have to show up and then be questioned and interrogated by an immigration officer. So that's not how I-90s, which are applications to renew green cards, work. Typically, it's a pretty informal process. There's no interview requirement. If anything, USCIS might schedule you for a biometrics appointment. But I tend to think that like for an I-90, immigration will probably just reuse your previously captured biometrics. Biometrics don't ever change, right? So they don't really expire either. So I told the client that um, if they're scheduled for anything, it would only be for biometrics, and that probably wouldn't even happen. Um, the other thing is when you are filing an I-90 to renew your green card, usually USCIS does not look at someone's entire immigration history to kind of revisit whether or not someone should be able to keep their green card. So for example, if someone who's a green card holder has um uh let's say like a criminal record, right? Let's say they were arrested, let's say they even have a conviction. In my experience, USCIS does not delve into these issues when filing a renewal of a green card. So that's a question that I get asked pretty often too, by clients. And the reality is that USCIS is not really looking into these eligibility for green card questions at the I-90 stage. When you apply for naturalization, that's a whole other story. Um, Absolutely, if you are thinking about applying for citizenship through naturalization, that's when immigration can actually look at your entire immigration history all the way back to when you first entered the US, and they can go over everything and check and double check to see if someone's green card was granted incorrectly, for example. I've had that happen a number of times to some clients who scheduled consultations with me. Um, it's because they went ahead and filed a naturalization application that immigration for the first time started looking at someone's history and realized, oh, well, we actually shouldn't have granted this person a green card. We did not realize that something happened, or maybe it was there in the file, but immigration didn't pick up on it or they overlooked it. And then sadly, during the filing of the naturalization that immigration discovers that someone is deportable, right? I've had some clients get placed into deportation proceedings because they proactively filed a naturalization application thinking, oh, well, I've been a green card holder for 5 years now. I qualify to be a US citizen. It's not as simple as a process as that. The naturalization application is pretty long and it asks a lot of detailed questions. So if you look at the form, that gives you an idea of all the things that immigration is looking at when deciding whether or not someone qualifies to become a US citizen.